Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of AP Mahesh Cooperative Urban Bank Shareholders Welfare Association versus Ramesh Kumar Bung and others, wherein the Supreme Court discussed a case where interim protection in the form of stay on criminal proceedings was granted by a high court to the accused persons. Before adverting any further, let us rebrush our memories by perusing Section 482 of the Code of Criminal Procedure. It reads as follows: Saving of inherent powers of High Court. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. Basically, Section 482 provides inherent powers of wide amplitude to the high courts to pass orders to prevent abuse of process of any court or to secure the ends of justice. Now let us understand the background of the present case. The dispute in the matter involved allegations of electoral fraud and loan fraud at a point of time when elections were to be conducted for a cooperative society. Several writ petitions were filed alleging electoral fraud, and some criminal complaints were also filed alleging electoral fraud as well as loan fraud. The High Court, while exercising powers under Section 482 of the Code of Criminal Procedure, granted interim protection to accused persons who were also the chairpersons of the said cooperative society on the ground that there is an overlapping of the allegations of electoral fraud and loan fraud, and that there is a tendency to foist criminal complaints at the time of elections. The bare facts of the case are not relevant for the purposes of this show, and hence I will not be discussing the same here. In the instant matter, the Supreme Court extensively referred to its earlier judicial pronouncement of Neeharika Infrastructure Private Limited versus State of Maharashtra and others that provided guidelines in relation to grant of interim protection in criminal cases. To know more about it, you can watch our earlier show in relation to grant of interim reliefs in criminal cases by visiting the link provided in the description. In Neeharika case, the Supreme Court had observed that an interim order on stay of investigation during the pendency of the quashing petition should not be passed routinely, casually, or mechanically, and the High Courts shall restrain themselves from passing the interim order of not to arrest or no coercive steps to be adopted, but whenever such an order is passed, the High Court shall clarify the contours and the meaning of no coercive steps to be adopted, since such term is broad and vague, susceptible to misinterpretation. In the present case, the court further clarified the guidelines laid down in the Neeharika case. Let us discuss the pertinent observations by the court in this regard. Firstly, the court observed that the Neeharika case does provide space to the high courts to pass interim orders of the nature no coercive steps to be adopted by supplementing the same with brief reasons. Secondly, the court explained that the Neeharika case frowned upon the practice of passing blanket orders that have the tendency of converting a civil dispute into a criminal dispute. Thirdly, according to the court, the entire sequence of events that took place in the present case points out that an attempt was made to convert an election dispute into a criminal dispute, as sometimes persons who raise these disputes manage to camouflage their real motive by words clothed in high moral fiber and strong legal content. Fourthly, the court cited an excerpt from the case of State of Haryana versus Bhajan Lal, wherein it was observed that inherent powers under Section 482 of CRPC may be exercised where a criminal proceeding is manifestly attended with mala fide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. According to the court, such reasoning was approved in the Neeharika case, and merely because some writ petitions were pending in the present case, The same could not be a ground to contend that the High Court got influenced by civil or writ proceedings while granting the interim relief to the accused persons. What needs to be seen is that whether the real nature of dispute is civil or criminal. Therefore, upon cumulative consideration of the legal principles just discussed, the Honorable Supreme Court held that the High Court was justified in granting interim protection to accused persons, and the impugned order cannot be said to be bad in light of Neeharika principles. Those were the observations of the court, so what are my concluding remarks? I concur with the reasoning of the court that what really needs to be seen is that in the garb of raising criminal allegations, a civil dispute must not be given criminal color. Electoral disputes and criminal cases are two entirely different species, and one must not be confused with the other. Even if there is a criminal element involved in an electoral dispute, then our electoral law has ample provisions to take care of them. And as rightly pointed out by the High Court, overcomplicating an electoral dispute with criminal allegations involving a different subject matter should not be entertained. Hence, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.